Order. Point of order, Sean McCrory.
I beg to move this House to sit in private.
The question is, this House sit in private. As many of their opinions say aye. Of the contrary, no. No. I think the noes have it. The noes have it. Just. The clerk will proceed to read the orders of the day.
Strategic Litigation Against Public Participation Bill, second reading.
No.
Wayne David.
Thank you, Mr. Speaker. I beg to move that the bill be now read a second time. Mr. Speaker, I have been a Member of Parliament for nearly 23 years.
No.
I know it's difficult to believe for some, but it's true. And on the first occasion, this is the first occasion I was drawn in the private member's ballot, and I'm pleased to say that I was drawn as number 4. And I thought long and hard about what would be the most appropriate, would be the best piece of draft legislation to bring forward. And I decided on this piece of legislation because I genuinely think it is incredibly important. And I will set out to the House why I think it is so important. I am bringing forward this private member's bill to tackle strategic litigation against public participation, widely known as SLAPS, in all its forms. Now, last year, I welcomed these measures, as did the Labour opposition, which were enacted in the Economic Crime and Corporate Transparency Act, which ensure that SLAPs relating to economic crime can now be tackled. And I'm pleased to bring forward a bill that expands on them. Reform to protect freedom of speech and the public interest is something that all parties in this Parliament hold dear. In all debates in this House and the other place, there has been broad consensus on the need for reform to tackle the pernicious effect of SLAPs. However, what was clear to both Houses was that the Economic Crime and Corporate Transparency Act measures do not go far enough. SLAPs have taken and do take many forms. I think it's also vitally important that we bring forward a piece of legislation that does genuinely tackle this issue in a truly holistic and rounded sense. There are many examples that we could cite of SLAPs, and I would just like to refer to a few of those examples. Examples which are high-profile cases, which have reached court and have received some publicity, and refer to others which have not received that much publicity. I would like to begin by referring to a particular case which has attracted a great deal of attention. And members will be aware of this case, I'm sure. There was in 2022 a defamation case reportedly brought against the journalist Tom Burgess, the Financial Times and the publishers HarperCollins by a Kazakh mining company. The case concerned a book by Burgess entitled Kleptomia, How Dirty Money is Conquering the World. That's just one example. A defamation case then brought by Roman Abramovich against journalists Catherine Belton and HarperCollins regarding her book, Putin's People. That was an excellent book, and I've read it. It's well worth reading. In fact, there was a legal assault on the book from a number of lawsuits in quick succession, justifiably provoking a group of campaigners for free expression to state that London's courts were becoming the venue of choice for legal action designed to quash critical journalism. Catherine Belton, the author of Putin's People, has called for the introduction of reforms to tackle this global industry based here in London. Hopefully, this legislation will begin to seriously address this significant problem. Then there was the case of Mercy versus Leslie, Here, a British business owner, Mohammed Al-Mersi, brought a defamation case against Charlotte Leslie, a former Conservative MP and Managing Director of the Conservative Middle East Council. This is a case I am familiar with because I am the Shadow Minister for the Middle East and North Africa. The case concerned a memo on Al-Mersi's background and dealings with Russia. This was put together in response to his attempt to become the chair of the organisation known as CNEC. The claim by Mercy was struck out because he had failed to show how this memo caused serious harm to his reputation. But it is not only high-profile cases where there are slaps. There is a case of Nina Creswell, who named the person who violently sexually assaulted her after her original report was dismissed by the police. She commendably wanted to alert other women who had become victims of sexual assault. But the man who was named sued her for defamation. Ms. Creswell won a landmark judgment last year, but the very fact that she had to fight the case at all demonstrates that the huge gaps that slap claimants are only too ready to exploit are there, and we need to address that fact. I've also heard stories of patients who have left negative reviews for botched plastic surgeries being issued with slap claims by the surgeons. I've heard of tenants who have spoken out about their uninhabitable housing being issued with slap claims by their landlords. This is wrong, and this must be stopped. Now, I've given a few examples of relatively high-profile cases, but also ones which are not so well known. But there are many cases which do not attract any attention in court, and there are many more which we do not know about because individuals are intimidated before legal proceedings actually commence. It is true that the data which the government has is only the tip of the iceberg. As I have suggested, slaps are extremely pernicious before any action reaches court. There are pre-action letters and legal pressures applied well before proceedings are initiated. And this often results in research or investigations being withdrawn before publication, or in some cases in a whole variety of different areas. The effectiveness of threats and intimidation are such that cases never see the light of day. Accordingly, this will never be reflected in available data. And when we think of the press in this country, let's remember that as a country that champions freedom both here and abroad, we must ensure that our free press, which is a real pillar of our democracy, never feels so vulnerable, but it self-censors on vital matters in the public interest. No one in the United Kingdom is above the law, and nor should anyone be above proper scrutiny on a matter which is in the public interest. As to the data we have, the provisional figures from the Coalition Against Slaps in Europe case are deeply concerning in themselves. They estimate that there are 29 slaps in England and Wales in 2022. This is up from 25 in 2021 and 11 in 2020. Cases August, the 2023 report recorded that the total figure in Europe over the last decade was 793.
Will the Honourable Member give way?
I will give way.
I'm grateful to the Honourable Member, and he mentions the Coalition Against Slaps in Europe. I wonder whether he agrees with the anti-slap coalition that the proposed bill, as it is drafted, would introduce a subjective test, that it would require a court to infer the state of mind and purpose of the filer. I fear this will create complexity, costs and delay, which would potentially make the bill ineffective. Does he agree?
I think it's an issue which has to be considered carefully, and indeed it has been given a great deal of consideration and much debate.
On that point, the Honourable Gentleman get back.
Well, can I just respond to the point that's been made first of all? I mean, I think it's an issue which is absolutely vital to be considered properly and deeply. And I will hope that very much the debate which we are having already, which will continue if we are successful today, into committee, so that further consideration may be given to it. But I think at the moment, I'm erring on the side of what is being suggested by my private member's bill. And I think the bill does strike a balance. And it's not quite accurate to talk about subjectivity and objectivity, because a judge will have to make a determination on the facts which are presented and his knowledge of how the case is being conducted. So I think at the moment I err in favour of saying that there's a false dichotomy, but it's something which should be considered further in committee, I hope.
Chris Clarkson.
Thank you very much, Mr. Speaker. Actually, I was going to sort of join in concordance with the Honourable Gentleman from Caerphilly. I think this is an excellent piece of legislation that we're discussing. I'm very broadly in support of it. I just really wanted to sort of rise in response to the comment from the Honourable Gentleman from the Liberal Democrat benches. Subjectivity is actually a fundamental part of our legal system already. We talk often of the man on the Clapham omnibus. It's the reasonableness test. So I don't think there is anything in this proposed piece of legislation that is out of scope or inappropriate.
As I say, I'm inclined to agree with that comment, as my bill suggests. But I think quite genuinely it is something which needs to have more airing and more consideration. And I think that detailed consideration in committee would be an appropriate place for that to happen. Now, Mr. Speaker, as others have said many times, most slap-related activity takes place below the radar before a formal court case and court claim is issued. There are a number of reasons why slaps are so bad, and why slaps claimants are so successful in their warped objective of perpetrating them. Commonly, the comparatively modest means of a defendant are leveraged against them to encourage retraction of the abandonment of the important research that would shine a light on questionable behaviour. Bullying tactics can include huge threatened litigation costs and damages, and all of the unbearable consequences such as bankruptcy and loss of homes and livelihoods, as well as the emotional distress that entails. All of this can cause huge hardship and psychological pressure. Sadly, many people are not able to withstand all of this. So many of the cases are like, if you like, David and Goliath. But it's as if David had no slingshot. I should be clear to the House why the unfairness of a legal system that allows all of this has to be challenged and changed. This is why I am bringing forward this bill today. We must eradicate the harms caused by this kind of aggressive litigation. We must protect publishers, authors and advocates from spurious claims that empower them to forge ahead for publishing legitimate stories. Grounded, well-researched, investigative reporting must be protected, not reined in for fear of colossal legal costs. And we must do our utmost to protect and empower ordinary people and give them the confidence to use the legal system of this country to ensure fairness in the public interest. Now, of course, protecting journalists or anyone else cannot be at the expense of denying claimants their rights of access to justice. But at present, the fact that claimants can wrongly exploit the justice system to obfuscate the transparency that is essential in a healthy democracy means that there must be an important balance struck. As things stand, this is clearly not the case. That is why I call for urgent reform today. Robust action to counter slaps in all their forms is needed, and it is needed now. Now, I have sought to work alongside the government to ensure that the approach underpinning the Economic Crime and Corporate Transparency Act, which is positively received across civil society, media and the legal professions, including the regulators, that approach remains largely intact in this bill as it achieves what is necessary. This bill will therefore keep, for the most part, the definition of a slap claim in the Economic Crime and Corporate Transparency Act, but it will also broaden in scope and capture all slaps. In future, any slaps cases where speaking out is in the public interest, including those publications on economic crime, will now be caught. Now, as to the specific components to that definition, first of all, the claimant will have acted to restrain the defendant's exercise of their right to freedom of speech. Secondly, the exercise of that right will have been in the pursuit of the public interest in exposing potential wrongdoing or other bad behaviour, such as illegality or untruths, or matters to do with public health and safety of the climate or the environment. Thirdly, the claimant will have misused litigation or its threat to cause harm to the defendant, and specifically harassment, distress, or expense that is beyond that which can be ordinarily expected in properly conducted litigation. The last point includes an important distinction. Legal cases almost always bring a measure of stress and expense to parties involved, given their serious nature. And as I've said, slap claims are often designed to generate excessive stress and expense. The pursuit of a remedy a mere fig leaf or excuse to allow the real harm the claimant wishes to cause. One of the things that distinguishes a slap claim is that the legal action is not pursued for the appropriate remedy, but instead as a means in its own right of bringing oppression to bear. To safeguard against that harm in an effective and proportionate way, including by ensuring legitimate claims can proceed, the bill will introduce a new early dismissal test. Claimants will have to show they are more likely than not to succeed at trial, and where they cannot do so, the case will be struck out. In addition, much of the harm in slaps claims lies in the risk of adverse costs that the defendants face. A properly functioning early dismissal mechanism will assist with removing many of the risks to the defendant. But for those slap claims that are not dismissed early, the bill will introduce a new costs regime protecting the defendants from costs they would normally pay if they were to lose the case. That will ensure defendants can defend themselves properly and ensure risks of costs do not force them to settle claims unnecessarily. The underpinning principles of this new costs regime are included within these provisions, but the detail will be introduced under the normal cost regime making powers through rules of court. These provisions together will require initially only new civil procedure rules to give them shape and to maximise their effectiveness, as the evidence currently available is that slaps are focused on the civil proceedings. However, these proceedings can be extended by regulation to any other proceedings in which they become necessary, such as the online procedure rules. I trust that the Government will make necessary regulations where slap claimants were well-resourced and able to exploit any perceived loophole, choose other courts in which to pursue slaps. This will also help to make sure that the bill is future-proof. Slaps are likely to evolve, and we need the legal infrastructure to be robust enough to meet those future challenges. As a result of this bill, I believe that courts will have the necessary tools and guidance to swiftly deal with all slap lawsuits which aim to stifle freedom of speech. Investigative journalists will also be empowered to expose wrongdoing in all its forms, whatever it may be. It is my hope that defendants in such cases will, as a consequence, feel safe from attempts to wrongly exploit our legal system. Journalists and others will be empowered to shine a light on criminal misconduct wherever they find it or whatever form it takes, without fear of spurious claims being made against them. As a matter of principle, Mr. Speaker, it is wrong for the unscrupulous, be that an individual or corporation, brazenly misuses our courts and legal system to further agendas to the detriment of the public interest. The public must know about wrongdoing and corruption so that our democratic society can function and the rule of law can be preserved. This bill recognises the breadth and depth of slaps. Currently, the law focuses solely on economic crime, but slaps can be found in all areas of the law. This all-embracing legislation against slaps is, I believe, a truly significant step in ensuring freedom of speech and removing a clear abuse of our legal system. I therefore, Mr. Speaker, urge colleagues across the House to give this bill their full support.
The question is that the bill now be read a second time. Nicola Rich.
Mr. Speaker, we in this House should all be proud of this country's international reputation for upholding the rule of law. In the current global climate and with the recent murder of Russian opposition leader Alexei Navalny, this is a freedom that we cannot take for granted. Navalny was an incredibly brave man, and his wife should be an inspiration to us all. Navalny wanted the world to know the true man Putin is, and today we are helping him in that aim. The protection of our legal system must be a priority for all in this House, ensuring that this reputation continues long into the future. It's for this reason that I must thank the member for Caerphilly for bringing this bill to Parliament today, and I urge all colleagues to support it. We are here today because we have to beef up the law to further ensure that we do not allow our legal system to be manipulated and abused by bad faith actors wishing to shut down freedom of the press and freedom of speech. In 2021, an investigation by the New York Times found that in 4 of the 6 years prior, litigants from Russia and Kazakhstan had been involved in more civil cases in England than any other foreign nationals. These cases were seeking orders to freeze assets of people worldwide. Individuals and corporations, many from countries where the freedoms we enjoy in this country do not exist, are using these strategic litigation against participation legal claims to harass and intimidate journalists and authors from sharing information which these individuals do not want to be seen and known. The prime example was the case brought by multiple Russian billionaires, including former Chelsea owner Roman Abramovich, who attempted to sue the author and publisher of the book Putin's People. The book delved deep into the relationships these oligarchs held with Russian President Vladimir Putin, a relationship these individuals cared deeply about when it suited them. But journalists can face legal action for pointing that out. There was also the case already mentioned against another journalist, Tom Burgess, by a Kazakh mining company over the contents of a book he published about illegally gained money in the global economy. Thankfully, this attempt to silence a journalist failed. I've raised the issues surrounding Putin's People before in this chamber, alongside many colleagues from across the House, including my honourable friend, the member for the Isle of Wight, whose work on this issue I'd also like to commend. The point of these lawsuits is to threaten the defendants with colossal legal costs, amounts no normal person can afford, and harass and intimidate them into capitulating. Putin's People author, Catherine Belton, and her publisher were left with a staggering £1.5 million legal bill following the case brought against them. This bill today presents the opportunity to further prevent this attempted silencing of authors and journalists by Russian billionaires or any other bad faith actor from happening again. It would put in place new rules so that claims deemed to be slaps can be dismissed and defendants protected from paying the claimant's legal costs unless justified. The government has been strong in their condemnation of slaps, and I was proud to see the Economic Crime and Corporate Transparency Act recently receive royal assent. This act allows judges to throw out slaps relating to economic crimes, and this is a good first step. At least 70% of the cases identified by the Foreign Policy Centre in 2022 were connected to financial crime and corruption. But we cannot and must not stop there, so I welcome the fact the government is supporting this bill today. We need to be preventing all forms of slaps once and for all, and this bill before the House today is the mechanism to do so. The urgency of this cannot be understated. The Coalition Against Slaps found that 820 slaps took place in Europe in 2023 compared to 570 in 2022, a 44% increase. The United Kingdom was named as a slap hotbed and the forum of choice for would-be slap initiators. A Birmingham Law School professor has said that the high costs of defamation litigation and the ability of foreign claimants to resolve disputes in the UK has made this country an ideal location for slaps. Other legislators have already taken action. Several US states have introduced similar laws involving these provisions, and the European Parliament is expected to approve similar anti-slap directives next week. As a result, Britain risks being left behind in an area we should be proudly leading if we didn't pass this bill today. As more places prohibit slaps, the chances of more cases being brought here in the UK increase further. We must be clear, the only purpose of slaps is to silence critics. There are no legal merits. We must act to protect this country's international reputation for upholding the rule of law, to protect our hard-fought freedom of speech, for justice and of the press. And we must make sure that journalists and publishers can publish information backed by sources and facts concerning any individual, no matter the size of their bank account. We in this country are proud of the leadership we have shown following the bloody Russian invasion of Ukraine. Passing this bill is a small but important way of contributing to that leadership. Thank you again to the member for Caerphilly for bringing this bill to the Chamber today, and I look forward to supporting this bill's passage through this House.
Thank you, Mr. Speaker. I want to begin by commending the member for Caerphilly for his work in bringing this bill before the House today, and to campaigners in what they are doing to prevent the misuse of litigation to suppress freedom of speech. Democratic and press freedom are fundamental to our rights, and in challenging corruption and the abuse of power. When whistleblowers speak out and when journalists and a free press report the truth, society is better for it. Just this week, Julian Assange's extradition appeal closed at the Royal Courts of Justice, and it's very concerning to hear that Julian Assange is unwell and unable to appear in court. I'm very conscious of the fact that there are ongoing proceedings, but I think what I am going to say is that human rights are central to what is happening here, not just in how he's been treated, just for the simple act of telling the truth, but if extradited, Assange could be at risk of treatment amounting to torture and other forms of ill treatment or punishment, including the death penalty. Fundamentally, Julian Assange's case has profound consequences for press freedom and democracy around the world. Because, Mr. Speaker, we cannot say that we stand for press freedom if freedom only exists if it does not challenge or go beyond what certain powers want. And as my honourable friend has said, one such way of undermining our freedoms is where the rich and powerful use the threat of costly legal action as a means of suppressing public criticism. That is why last year many of us welcomed amendments to the Economic Crime and Corporate Transparency Act to allow for UK judges to be given new powers to dismiss lawsuits attempting to silence those speaking out about economic crime. But as has been said, however, the limited scope of the bill, as well as certain shortcomings in the text itself, those amendments fell short of providing meaningful protection against slaps. There is currently an inequality in the current legislation as it stands for those subjected to slaps that do not relate to economic crime and corruption. We know that powerful men use their power and the law to silence women, often described as gagging orders. The purpose of these proceedings is to silence, intimidate, discredit and further disempower survivors. Some campaigners call it gendered censorship. It's a phenomenon in the UK, but it's also a global phenomenon. Therefore, whilst I welcome the ambition of the bill before the House today, I still believe there may be scope for further amendments concerning the definition of what a slap is, so that domestic abuse is fully included in its scope, particularly in its understanding of public interest. I say this because we all know of a series of libel cases where wealthy men have sought to protect their reputations from women who accuse them of abuse. The legislation as it currently stands puts these survivors at a disadvantage. For example, under the Defamation Act 2013, the defendant in libel cases can argue a public interest defence, but this is not available to survivors. And I would appeal today to the government to look into this carefully and look into how provisions in the proposed bill can be not just extended in terms of the civil courts, but also in the family courts as well. In January 2022, I participated in a backbench business debate on the use of lawfare and strategic litigation against public participation by those seeking to suppress public debate, bully people into submission and conceal vital information that is in the public interest. I described my own experiences of lawfare being used against myself, and the House will be aware that I was completely cleared and vindicated in Snaresbrook Crown Court after what I and many others in my constituency and around the UK viewed to have been vexatious litigation pursued with the purpose of shutting down my public participation as a democratically elected Socialist Member of Parliament and as a survivor of domestic abuse. The use of lawfare by abusers to pursue their current or ex-partner is coming more and more to light. And I'm aware that the occurrence of civil litigation cases of this nature has drastically increased, particularly following the widely publicised Amber Heard versus Johnny Depp case in the US. And the most common proceedings we see are brought by men accused of sexual misconduct and or domestic violence, launching vexatious cases in relation to defamation, libel, misuse of private information, harassment and press injunctions. The UN Special Rapporteur on Freedom of Expression, Irene Khan, writing in a dedicated report on the issue of gendered censorship in 2021 said, and I quote, "In a perverse twist in the hashtag #MeToo age, women who publicly denounce alleged perpetrators of sexual violence online are increasingly subject to defamation suits or charged with criminal libel or the false reporting of crimes. Weaponising the justice system to silence women feeds impunity whilst also undermining free speech." And I would add to this, barristers Jennifer Robinson and Dr. Yoshida have argued that they make the argument really in their book that the current situation strikes an unfair balance between his right to reputation and her right to freedom of speech. And what's missing in the current legislation in the UK as it stands is a recognition of the importance of her additional rights, her right to live a life free from gender-based violence and her right to equality. Mr. Speaker, the practice of abusers weaponising civil litigation against survivors as we know it is a continuation of abuse as well as an additional trauma. I find myself often asking the question, if we cannot speak about violence against women and girls, then how can we even tackle it? By their nature, these cases misuse the courts and are brought against survivors to silence them and re-victimise them, both emotionally and financially. And I appeal and urge again for the government to really look at the situation in the family courts as well as the civil courts as well. I believe no one should suffer domestic abuse, and anyone in such a situation should be supported in speaking out. This is a matter of public good, and it is a matter of public interest. Thank you.
Thank you very much, Mr. Speaker. It's a pleasure to follow the Honourable Lady from Poplar and Limehouse. Can I start by congratulating the Honourable Gentleman from Caerphilly? I think he has brought to us an excellent private member's bill. This is entirely what we should be doing with Friday sittings. I love Friday sittings, Mr. Speaker. I've outed myself as a geek on multiple occasions. This is, for me, what it's really about. It's actually coming and talking about stuff that's really important to people and at length. I will also out myself as a lawyer. I shall wave my LLB about. So this is something I am very, very passionate about. I believe very, very keenly in our legal system. It is the jewel in the crown of our state, which I think is, sort of par excellence, second to none. And it deeply grieves me when something so important is perverted for the narrow interest of a small cadre of people who have quite rightly deduced that there is a technical flaw available to them and they have enough money to exploit it. This system should not be exploitable if you have purely the financial resource to do it. We should not be able to purchase justice in this country, and people do that. Which is why I want to really speak only to sort of two main issues that I sort of have deduced from reading this private member's bill, which I will be supporting fulsomely, I hasten to add. The first one, and I think it really is a matter for when this reaches committee stage, is to talk about how we address the concept of forum shopping. Forum shopping is a serious problem. This country has a particularly robust approach to defamation legislation, and it means that, for example, if I were to publish a book like Putin's People, It could be the case that actually it's published in 18 different countries, but I only get sued in this one because this country is the one that is most technically adept at allowing somebody to get money out of me and keep me quiet. And it will then prevent me from being able to publish that book in other places. It will gag me effectively from one country in other countries. I do think there is something we can do in that space. I think the Honourable Gentleman has put together an excellent bill here, and it's one for the sort of pinstripe suited. Well, I'm actually not wearing a pinstripe suit today, but it's one for the sort of the geeky bods to get into. But I do think that's something that we are going to have to drill down into in order to ensure that this is as robust as it can be. But I am very, very happy with the direction that this is taking. The other thing is actually addressing what this is really about, and it's not about technical amendments to the legal system, as much as I love those. It's about freedom of speech. Freedom of speech is one of the most fundamental rights in every democracy. The United States Constitution starts with Congress shall pass no law respecting an establishment of religion, nor prohibiting the freedom of speech or of the press, or the right of the citizens to peaceably assemble to petition their government for a redress of grievance. And that is an incredibly powerful and potent set of clauses that prevents this from happening in the United States. We have to rely on Article 10 of the European Convention on Human Rights, and I will say now, actually, for the avoidance of doubt, you will get me through a wood chipper faster than you'll get me through a division lobby to take us out of that. Article 10 is incredibly important, but it is not adequate to the task that we have ahead of us, and that's why this is such an important bill. I want to be able, as a Member of Parliament, not to rely on the fact that I have immunity in this chamber, to be able to go out and talk about what is correct and right and proper and decent. And I cannot do that without fear or favour at the moment, because this lawfare system, and I think the Honourable Lady coined that term, very effective way of describing what's going on here, is basically being used to destroy one of the fundamental principles of our democracy. The Honourable Gentleman is entirely right and proper to bring this here. I will enthusiastically support this. If he needs people for Bill Committee when it gets to that stage, I will be there. I'm afraid I will be talking a lot.
Andy Slaughter.
Thank you very much, Mr. Speaker. It's a pleasure to take part in this debate, particularly with you in the chair, Mr. Speaker, because this is essentially a debate about free speech, and I know that's something of great concern to you, not only in this chamber but outside this chamber. And I know it's a particular concern to my old friend, the member for Caerphilly, and I do congratulate him on bringing this bill forward today. He himself is quite busy with his other hat on as the Shadow Middle East Minister at the moment, so it's good he has time to be on a Friday to process bill as well. I hope he has the government support with this bill. It's right to say, and let's give them a little bit of credit, not too much, but a little bit, that since this became a live issue for this House, and I would say that was when the I remember for Halton Bryson Howden held his debate in January 2022, lawfare and the UK court system. Lawfare slaps. I think slaps, as with everything American, it's taken over the language here, but lawfare effectively the same thing. And that was really the first run out. I replied for the front bench of the opposition on that day. There were many very strong contributions, and it put it on the map, and indeed on the government's map. And there has been some progress. We've heard about what is in the Economic Crime Act dealing with the issue of slaps, but in a particular way and for a particular type of offence, i.e. around economic crime. There is the anti-slaps task force that is meeting, but it is somewhat disappointing that the government has not brought forward its own comprehensive legislation in relation to this issue. I would hope they are going to use the agency of my honourable friend to get something on the books within this Parliament within the time that is available. But nevertheless, I think that we haven't done the entire job now. That is no criticism at all of my honourable friend, and I don't know whether that is an invitation for me to go on the Bill Committee as well. But let me just deal with 3 points, if I may, in relation to where we've got to now. Three issues that I think need slightly further attention. The first, which my friend mentioned, was the issue of slaps taking part in the dark, pre-issue, as it were. Now, there has been some attention by the Solicitors Regulation Authority to this in issuing guidelines, but I think there is still quite a strong feeling that many slaps were effective long before they would get into the courtroom, because the intimidation that is placed, and I don't think we can underemphasise this in any way, that is placed on individuals. They may be authors, they may be journalists, but they may just be individual members of the public. They may even be corporations. And yet they cannot take the risk because they are up against people not just with deep but bottomless pockets. We heard about the £1.5 million cost for Catherine Belton in relation to Putin's people. That was pocket money for Bromwich, but for a publisher, let alone a journalist, it is a huge and significant sum of money. So I think a more comprehensive view of how slaps can act is there. And that is important in relation, as I say, to this question of resources. And although I don't want to disagree with my old friend, I think we do need to look at this point which the Anti-SLAP Coalition and the NUJ has raised in relation to a subjective or an objective test, which was raised by the Liberal Democrat member earlier on. It's not easy, and yes, one can obviously there are subjective as well as objective tests throughout the legal system. Nevertheless, there is a real fear that the need for a defendant to show subjective elements here will be a path back in for the claimant to tie proceedings up in knots, to complicate things, to drag things out in that way. I don't know what the solution is, but I think we should at least explore that, and I think we should listen to the the expert organisations, particularly NUJ and Anti-SLAP Coalition, who are urging that course on us. I will give way.
Richard Ford. I'm grateful to the honourable member. Does he think that perhaps a minor amendment could be introduced which added an objective test based on observable features of abuse, and maybe that could help prevent litigation being misused so as to suppress freedom of speech?
It does rather sound like one wants to go on Bill Committee as well, and is drafting his amendments in his head. I've never known a Bill Committee be so popular on a private member bill as yet. But yes, I mean, there may be. I'm not a legal draftsman, and I don't know what the answer to that is. But I think we need to bottom this issue out, because it seems to be the one that is attracting most attention. There are other issues that have been raised in relation to overlaps of the Defamation Act, in relation to costs. There are provisions on costs in this bill. It's whether they are driving down costs as far as it is as they can, and indeed on public interest. So there are a number of areas that could be further explored, even within this short bill. And the third point I was going to make is on this issue of costs. Cost is vitally important here. I mean, it's an often neglected part of legal process. And I just say this because this is the hobby horse of my own. We've just discussed the media bill in this House, and we've just discussed the repeal of Section 40 and effectively taking Leveson Part 1 out of the equation in terms of having a level playing field for those who are victims of press abuse, if I can put it in that way. And I cannot to the life of me see what the difference is between what the government appears to agree with on slaps, which is using costs as a weapon to prevent people getting their just desserts and getting their day in court. They appear to support it entirely in relation to legislation like this, but when it comes to the media itself. Now, of course, it cuts both ways in relation to Leveson. Leveson also provided a formula for protecting small publishers against exactly the sort of people who take part in slaps. Indeed, he could have used the word slaps in his report. But it also protects the innocent victims of press abuse, because, again, the press magnates, I'm not talking about journalists and small publishers here, I'm talking about the major publishers, also have bottomless pockets in this way. And I would ask the Minister, perhaps in replying today, perhaps in the course as this bill goes through, to think again, at the very least, how they will approach this issue of small publishers and journalists being sued in order to protect the so-called privacy, but often the nefarious activities of very wealthy individuals and corporations. And as I say, Mr. Speaker, this can affect anyone. It can affect journalists like Tom Burgess, who, as we heard, won his case. I should say it hasn't discouraged him, because I'm hoping to go to his latest book launch this coming week, as he's publishing Cuckoo Land, Where the Rich Own the Truth. I think I can give him a little plug in here, soon available from all good bookshops. But it takes huge courage to risk everything, to prosecute, simply in the course of prosecuting your own employment and your own job, with the risk of bankruptcy, of the risk of being perhaps dropped by your publisher, not, I have to say, certainly in Tom's case. We heard about the case of Charlotte Leslie, a former colleague of ours, and how she was effectively persecuted through the courts. We are lucky, we have the protection of privilege here, but when we step outside here, or for anybody else who is with good intent trying to simply tell the truth, can become a victim in that way. And even organisations like the Serious Fraud Office, which is still being prosecuted in the courts by the Eurasian Natural Resource Corporation, an organisation which, again in good faith, Serious Fraud Office launched action. There was retaliatory, I would say, slap action, and although that original action by the SFO has been discontinued, the slap continues. This really does look like a topsy-turvy world, when organisations that we should rely on to regulate society, and I include investigative journalism, I even include members of Parliament in that, and I certainly include criminal investigation organisations, become themselves the victims of the people who they would wish to call out. That is why we urgently need a much more comprehensive approach to slaps. And that's why I fully welcome this bill and will support it today, but think we can probably do some more work on it, and the government can express in responding today its strong support and its desire to go further.
We now come to Shadow Minister Kevin Brennan.
Thank you very much, Mr. Speaker. This could be quite a big day for the Welsh, actually, with the Honourable Member for Caerphilly presenting his bill, and my Honourable friend, the Member for Newport West, presenting hers later, I hope. And I hope, Mr. Speaker, later on to move from the front bench to the back bench to present my own bill later on in proceedings. So that's three Welsh bills this morning. And of course, we have on the front bench here from the Opposition Whip's office our honourable friend as well. So a big morning for the Welsh. Can I congratulate my friend who we came into the House together in 2001, the Honourable Member for Caerphilly. Hard to think it's nearly 23 years ago. But can I really congratulate him on his first outing in all that 23 years here this morning in presenting his private member's bill, and I'm glad he was successful in the ballot. And it's a very important bill. For years, strategic lawsuits have enabled the wealthy and powerful to weaponise their wealth to sue critics into silence, and it's very important, I think, that this House, as honourable members have said, votes to put an end to these tactics that gag the press and intimidate people by who are asking legitimate questions, by threatening them effectively with enormous legal costs, lawfare as it's been referred to today. And can I thank the honourable members who have participated in debate from West Bromwich East, Poplar and Limehouse, Heywood and Middleton and Hammersmith, who all spoke, I think, extremely effectively in support of the bill, but also raising appropriate questions about how the bill should proceed in committee. Can I also say that I'm pleased that the bill has cross-party support, and I understand the government is in full support of the bill, and confirm that it has our support from the front bench on this side. It's a step forward that the scope of protection provided for in the bill is not limited as currently to economic crime. Slaps, often masquerading as defamation or privacy claims, are not really about seeking justice, they're about imposing silence. Exploiting the financial and emotional strain of proceedings to discourage individuals from exercising their right to speak on matters of public interest. And we on this side of the House have long recognised the danger posed by slaps to our democratic values. We've already committed, actually, to introducing legislation to halt the ability of Russian oligarchs like and the super wealthy like Roman Abramovich, for example, who's already been mentioned today, to use their wealth as a weapon against those who dare to scrutinise their actions. And the background to my honourable friend's bill is rooted in a disturbing trend of legal harassment, from aggressive pre-action letters to targeting of vulnerable financial defendants. Slaps undermine the foundations of accountability and freedom of speech. And the enormous legal costs threatened by slaps serve not justice but the suppression of truth. This bill is not merely a response to a growing trend of legal harassment, it's a declaration of our values as a society that cherishes free speech and the rule of law. It broadens the scope beyond economic crimes, offering protection across all public interest discourse, ensuring that no avenue is left for the misuse of our legal system to suppress legitimate scrutiny and accountability. The legal reforms proposed by my honourable friend in his bill are both necessary and timely. They reflect a deep understanding of the challenges posed by slaps, as outlined in evidence sessions at several parliamentary committees. And by providing mechanisms for early dismissal, costs protection, and extending protections to all courts and tribunals, we're fortifying our defences against the abuse of legislation. Now, as we consider the provisions of the bill, let's remember the individuals who have been unjustly targeted by slaps, and institutions indeed. Their struggles underscore the imperative for this legislation, and I'd like to acknowledge the efforts of campaigners, including the UK Anti-Slap Coalition, for their tireless work in bringing this issue to light. And we must ensure that our legal system serves justice, not the interests of those who seek to wield it as a tool of oppression. I acknowledge, and I'm sure they'll be rehearsed in committee, some of the issues that have been raised about the bill, and I'm sure we'll have a deeper discussion of those in committee. I think, in addition perhaps to some of the measures that have, or the concerns that have been raised, I think we also need to make sure, and as I'm sure it doesn't, but that the bill doesn't prevent ordinary people who wish to restrain the publication of libels and intrusions by wealthy publications from being able to do that in the law. As my father always used to say, in life we should help the weak against the strong, and I know that's the intention behind my honourable friend in bringing forward his bill this morning. So I urge all honourable members to support the bill. In doing so, we're taking a stand against the tactics that gag our press, intimidate our citizens, and erode our democracy. It's a step forward in an ongoing effort to protect freedom of expression and ensure that those who seek to report on wrongdoing can do so without fear of retribution. In the fight for justice and accountability, there's no room for silence. This bill can help to end the scourge of slaps and reaffirm our dedication to the principles of democracy and freedom.
Minister Michael.
Thank you, Mr. Speaker. May I first of all start by congratulating the Honourable Member for Caerphilly for bringing forward this bill and the numerous campaigners who have been pressing this issue for many years. As we've heard, strategic litigation against public participation, or SLAPs, is an abuse of our courts and of our laws by corrupt individuals seeking to stifle free speech and a free press, two of the very linchpins of our democracy. And if I may just refer to what the Honourable Member for Poplar and Limehouse said, I appreciate that the issue, I can't talk about the specific case, but I can reassure her that this bill widens the scope from beyond what was in the Economic Transparency Bill and now talks about all kinds of behaviours. I'm more than happy to discuss the specific issues with the Honourable Member for Caerphilly, because it is his bill, to make sure that the specific issues she wishes to see covered, to see what we can do to either reassure her or to accommodate her. If I may, Mr. Speaker, we know that this issue became increasingly pressing when the Russian oligarchs and their allies of Putin used this process for their own ends. Alongside them, we saw behaviour by multinational corporations or disreputable landlords to use and abuse our processes. Slaps must always be taken seriously and tackled swiftly. And in this House, we have the ability and the privilege to ensure that abuses such as these are addressed head-on. This House stands for free speech and for holding the powerful to account, and for always seeking to ensure that the best interests of the public, in the widest sense, are being served by the law. Slap-style litigation is an abuse of power designed to inhibit public interest investigations and reporting. The harm that slaps cause is not only that they stifle public comment by forcing its removal or editing it, they also discourage journalists, academics and campaigners from investigating issues in the first place, leaving matters of public interest undiscovered and the British public in the dark. In this way, the effect of slaps is far more pernicious. We cannot sit by and allow our media to feel that some people and organisations cannot be subject to scrutiny just because they have unlimited financial firepower to mobilise aggressive legal tactics. And to quote Andrew Galizia, whose mother Daphne, a Maltese investigative journalist, was murdered in 2017, the aim of these lawsuits is to deprive the target of time and resources and deter others from taking up the same story. His mother was subject to 43 lawsuits at the time of her death. Whether a claim is aimed at an author, an academic, a journalist or a private individual, this abuse of the law to muzzle the free press must not go unchecked. We will not allow our justice system to be abused. And in our response to the government's original call for evidence, we said that while there were powers enabling courts to strike out cases as an abusive process, these powers needed to be strengthened to counteract the very sophisticated but very aggressive actions brought by slap claimants. The House will be aware of some high-profile cases that have shone a light on slaps, cases such as that brought by the British journalist Tom Burgess, who members have already mentioned, who was sued for libel in the High Court by ENRC, an oligarch-owned mining company, following his publication of Kleptopia, How Dirty Money is Conquering the World. There were multiple claims issued against Tom Burgess by ENRC, targeting him as an individual author rather than his publisher. These claims concerned his tweets, his podcasts and his articles which mentioned his book. This case was dismissed early on. The statements complained of were found not to be defamatory, and Mr. Burgess was vindicated. But how many more cases do not reach our courtrooms due to the intimidatory tactics and costs run up by aggressive claimants before proceedings are even brought, which I think is the point raised by the Honourable Member for Hammersmith. If I could just address a couple of points that he raised at this juncture. We have continued and will continue to engage the SRA. As the Honourable Member mentioned, warning notices have already been issued. The fines for behaviour or misbehaviour by solicitors' firms have been increased. And of course, that pre-action behaviour is a legitimate cause of concern. And the government will continue to engage with the regulator to see how that can be further addressed. And as so many people have volunteered to be on the Bill Committee, I'm sure that's something that we can look at with the indulgence of the Honourable Member for Caerphilly. We'll be able to look at in some more depth. Mr. Deputy Speaker, there is evidence that the number of slaps is increasing year on year. In 2020, there were 11 cases in the UK. In 2021, 25. And in 2022, 29. And such worrying and abusive conduct by those with deep pockets attempting to financially bully dissenting voices is unacceptable in our democracy. The courts must not be a pawn in these underhand attempts to cover up corruption and wrongdoing. Slaps are a modern-day struggle between David and Goliath. On one side, we have the individual journalists, academics and authors up against the extremely wealthy and wealthy individuals and corporates with unlimited resources on their side. We cannot let this type of intimidation and harassment stand. It is right that wrongdoing and dubious deals are laid bare for the world to see. And those who would expose this should not be afraid of the repercussions of doing so. And that's why the government listened and brought forward legislation in the Economic Crime and Corporate Transparency Act of 2023 to tackle slaps claims connected to financial misdeeds. This act meant we were the first country in the world to legislate against slaps at a national level. And that's something that, whilst we can argue whether it was overdue, but certainly we were the first to do it, and it's something that we ought to take some pride that this legislature acted faster than most. Moving forward, that act only gave cover to a small part of the slaps regime. And this act targeted only one part of economic crime. And that's why this private member's bill seeks to address the gaps, and it does make sure that the definition of slaps is more comprehensive. If I may, the honourable gentleman raised the issue of behaviour in the test of objectivity and subjectivity. And if I may just cover off that point, Mr Deputy Speaker, the issue of subjectivity is not unusual, and the courts do consider and will consider all evidence before it comes to an assessment, and including an explanation from the claimant as to why their claim is reasonable. And the courts, of course, are well versed in taking that information into account. If you like, the test of subjectivity or intent is not unusual and is well established in our court system. And if I could be helpful, Section 2 of the bill does actually give some specific examples of types of behaviour that would be deemed to be slaps type behaviour. So there is, I believe, a careful balance between the standard practice of intent whilst tightening up some areas that would clearly give some objective guidance to the judiciary as to what is slaps behaviour. This bill also, Mr Deputy Speaker, follows on from the Economic Crime Act in terms of establishing a cost protection regime which limits the legal cost in slapped claims, protecting the defendant from the obscene costs run up by claimants to increase the intimidatory effect of their claim. This will also help address the glaring inequality of arms between the parties in these cases. And of course, one of the big steps forward, Mr Deputy Speaker, is the fact of the ability to have early dismissal, so that these cases don't rumble on, racking up fees, particularly for those defendants. The ability to strike out at an early stage is a big part of the armoury on cost protection. But our reforms also have to ensure there is a balance between defending people from slaps-type behaviour, but also ensuring that we do protect what is a fundamental part of our system, which is access to justice. And it is for the courts and judiciary to determine whether a case is a slap and whether it has merit. What we have done is act to remove the level of fear and risk that these cases can engender. And the government is glad to be able to welcome and support this bill, which builds on the important progress already made. I thank the Honourable Member for Caerphilly for seizing that moment to introduce a private member's bill, and it is a really opportune time that we can continue to build on what we've done so far, but make it more comprehensive. As he has outlined so well, the government has found that the scourge of slaps is, unfortunately, spreading into new subject matter areas such as sexual harassment, clinical negligence, landlord and tenant disputes. The whole purpose of this bill is to tackle behaviour, and if the behaviour, to coin a phrase, if it looks like a duck and it quacks like a duck, it's a slap. And though this is a major step forward, so that's rather clumsy English, and I'm sure Hansard will correct me, Mr Deputy Speaker. It is the time that we legislated so that the majority of slaps cases were thought to be linked to economic crime, but it's time to move on and make the definition more all-encompassing. Mr Deputy Speaker, I would like to just make sure that a couple of points raised by honourable members are covered off. My honourable friend for West Bromwich East raised the Belton case. Again, that particular case, whilst not commenting on whether that case and its specifics form part of the formation of the bill that the honourable member for Caerphilly has brought forward, all of that information in all the cases for slaps form part of the call for evidence. And so I can reassure her that the activities in that particular case will have formed part of the foundation of bringing this bill forward. And if I may also cover the point raised by my honourable friend for Heywood and Middleton regarding forward shopping, that's an issue I will look at, but one I am sure he will raise in his customary fashion in the Bill Committee. But I'm sure my honourable friend for Caerphilly would urge him not to talk quite as much as he's promising to. Mr Deputy Speaker, if I may say, it is a credit to this Parliament that members of all parties have rallied to support action on this issue and to introduce new laws that help ensure the integrity of our justice system and support the freedoms and protections that we all cherish in our society. In some ways, that private members' bill is a most fitting way of completing what the government has started. I've commented that the work we're doing with the Solicitors Regulation Authority to ensure that they tighten up their regulation, and we will continue to engage with the SRA, as I've said. I'd like to pay tribute to the UK Anti-SLAPP Coalition, who have been enormously effective stakeholders that have supported the government's efforts, and I thank them for their consistent engagement and clarity on this issue. Within government, the Department of Culture, Media and Sport launched the SLAPPS Task Force last September with a remit to develop non-legislative recommendations to tackle SLAPPS, and good progress has been made on a number of fronts, and I thank the Secretary of State for DCMS for her tireless commitment in this regard. Internationally, the UK was represented as an expert member of the Council of Europe's Working Group on SLAPPS, which concluded its mandate in December 2023. The draft recommendation that was produced over the course of 2 years will now make its way to the Committee of Ministers, and we trust it will eventually be adopted across all 46 member states. Mr Deputy Speaker, in conclusion, the Government acted last October to legislate against SLAPPS because we could not allow our courts to be abused and our legal system manipulated. That's why we are pleased to support this bill, why we will continue to make sure that those who speak out against corruption, who hold powerful to account and who guard our freedoms through their voice are protected. Finally, Mr Deputy Speaker, may I once again thank the Honourable Member for Caerphilly for bringing forward this bill, and also the officials at the Ministry of Justice for providing all the necessary support for his bill as we move forward. Thank you.
Leader of the House, Wayne David.
Thank you, Mr Deputy Speaker. And could I say, with the leave of the House, I am very pleased that we've had such a good debate this morning. It has been, I think, laudable that so many members on all sides of the House have taken the time to attend and make such excellent contributions. And I would also like to pay tribute to people outside of the House, notably the Anti-SLAPP Coalition, who have worked tirelessly on this issue for some time, and their input has been of tremendous value. Equally, I would like to thank the Ministry of Justice and the civil servants there for their assistance and their briefings and their constructive engagement at all times on this bill so far. Could I say that there have been a number of issues which are very, very important issues as far as many members are concerned. The so-called issue of subjective tests, for example. You know, I'm inclined to agree with what the Minister has said in his summing up, but I do accept there's room for further discussion on this issue, and I think that we can go into some detail on this issue when, if the bill goes to a committee. Could I also say, as far as the issue of costs is concerned, that is a fundamental issue, I agree, and I think that a number of members have cited examples where this issue is of tremendous importance in ensuring that justice is actually seen to be done and is done. And I would just like to refer to a contribution by the author Catherine Felton in her evidence to a select committee here, when she made reference to the fact that in London it can cost as much as £9,000 for one letter addressing concerns which have been expressed by individuals. And if one letter costs £9,000, we all know how much an entire case could cost. And surely that cannot be right. If we're in a democracy in which freedom of speech is absolutely pivotal to ensuring that we have a country which is prides itself on freedom of speech and which allows justice for all. So I very much hope that this bill will continue its progress through the House and will reach the statute book. And I think if we do that successfully, it will be a huge step forward for parliamentary democracy.
Yeah. The question is the bill now be read a second time. As may 11 in say aye. Aye. 1, 3 no. I think the ayes have it. The ayes have it. Congratulations.